Okay, thank you.
Mr. Ramakhali, just to proceed from the questions of Justice Collipin, you indicated at the beginning of your argument, you gave an example of the Palestinian.
Yes.
Who then, after the 7th of October 2023, would be in a different situation.
Yes.
Let's just presuppose that that Palestinian had applied for refugee, had applied for asylum.
Yes.
But had been refused it on the grounds that it was just the same as any member of the population, they'd be subjected to this.
Yes.
But then comes the 3rd of October, was it the 7th of October? You seem to imply that thereafter the situation had changed and that refugee would have a right to asylum. But on your version, because they've applied the first time, too bad, we send them back to a country where there's a genocide.
Yes. Well, yeah, well, Justice Nichols, I accepted the difficulty, and it's one that we pointed out. But as I've said, the department has to act within the constraints of the Refugee Act. It can't do no more in a mandamus application than that which the Act contemplates.
So in that situation,
yes,
they would be returned back to Palestine.
Yes, because regrettably, that's precisely what Section 24(5) says. That once you've had the benefit of the full process, you are to be dealt with in terms of the Immigration Act. Had there been a process of subsequent or further applications, that would have been set out. And that is a lacuna in the law. We absolutely agree with the respondents on that. The only question is, how do you fix it in a mandamus application?
Basically, your argument is that a second application can never be entertained on whatever basis.
On the current framing of the Act.
Current framework.
Yes, currently, yes.
Mr. Ramakhali, could I just follow that one up? What of an appeal in relation to changed circumstances? Where does that fit into the mix?
We deal with this, Justice Savage, in our heads of argument, where there's a judgment, and I'll find it in our heads, that essentially states that when a party is in the process of an appeal, they are entitled to basically set out a wholly new case on appeal or review. But that's before you get to the final determination of the process. There you are, it's what's called a wide appeal. You are entitled to raise an entirely new case in that appeal process. So,
Palestinian example, would it be open to the Palestinian individual then, to refugee, to then bring an asylum, to ask for an appeal on new facts for the application to be reconsidered under 24B5? Is that
yes, so they could notionally bring an appeal, reopen the appeal, the necessary condemnation of whether the story is, and there they could throw in as many new facts as they would be entitled to. But what they wouldn't have is a right to start the process again with an interview and a review board, etc., etc. Yes.
constraints on the appeal?
As I understand it, we refer to the decision of the High Court. I'm just not sure whether it's been endorsed by this court. It's in our heads of argument in paragraph 86, the decision of Tantouche versus Refugee Appeal Board, where the court said, the applicant has transiently criticized the RAB's misinterpretation of the nature of function as an appellate body. As explained, because of the RAB's powers to gather additional evidence, the intention of the legislature was to confer upon the RAB an appellate jurisdiction in the wide sense, meaning that it is not bound to pronounce within the merits within the four corners of the record of the RSDO. An ordinary appeal is one where the appellate body is confined to the record of the body being appealed against. A wide appeal is one in which the appellate body may make its own inquiries and gather its own evidence if necessary, and etc. So, and I think even in our application for leave to appeal, we say the remedy on the current framing of the Act would be to bring a wide appeal as contemplated in Tantouche. But it's not a reapplication process. It's set out in our application for leave to appeal. Yes.
Can I ask you to assume, for purposes of my questions, that when Ms. Irankuda left Burundi and up to 2014, when her application was finally rejected, circumstances in Burundi didn't entitle her to refugee status? In other words, there weren't refugee circumstances prevailing. But I ask you to assume, for purposes of my questions, that those circumstances were in existence by 2020.
Yes.
I understand your argument to be that if a person from Burundi who was just illegally in South Africa made a first application in 2020 and those circumstances were accepted by the RSDO, that person would be awarded refugee status.
Yes, for the purpose of the question, indeed, yes.
Ms. Irankuda tried to persuade an RSDO in 2014 or earlier that those circumstances prevailed but failed. And since that is not challenged, we must accept that Ms. Irankuda, like my notional illegal immigrant in 2020,
Yes.
was a person who left her country and as of 2014 was not a person who was absent from her country because of the existence of circumstances contemplated in Section 3. But you say because she failed in her first application, she is precluded from receiving the same treatment as the person who didn't bother to apply in 2014 but did apply in 2020.
Yes.
Why, given that the 2014 rejection stands, why is she in a different, why is Ms. Irankuda in a different position from my notional illegal immigrant? Because she is a person who, like that person, left her country and was in South Africa as of 2014, at a time when circumstances did not yet exist entitling her to refugee status. Why is she not exactly similarly placed to my notional illegal immigrant?
Justice Rogers, it might very well be that they might be in the same position. The only question is whether there's a right to reapply for the person who applied in 2014 and then seeks to apply again later. And again, because we're dealing with whether there's a clear right or not, it might very well be in a proper constitutional challenge that the court strikes down the failure to legislate for such a situation. But that's not where we are.
Well, since your answer to questions that some of my colleagues have posed is not to say that it is right and just and in keeping with the non-refoulement principle that the Palestinian should be returned to Gaza in 2024, you say it's a lacuna. The act can't be interpreted in a way to avoid that outcome. So perhaps that is something I now just want to explore with a couple of further questions. Section 3 sets out that a person qualifies for refugee status for purposes of the Act, and then the circumstances are set out.
Yes.
Reading Section 3, Ms. Irankuda did not qualify for refugee status in 2014, but she did in 2020. And the way Section 3 is formulated doesn't say that she doesn't qualify for refugee status because an earlier application failed. It's absolute in its expression.
Well, with respect, no, Justice Rogers, because if we, on the facts, on the factual dispute, the circumstances alleged by Ms. Irankuda.
I've asked you to assume my
If it's
of my questions.
Yes, well, so what Section 3 does is it tells the RSDO who qualifies for refugee.
Well, it says a person qualifies for refugee status.
Yes.
If. So Ms. Irankuda didn't qualify for refugee status in 2014, but she did in 2020.
Yes.
And Section 3, at any rate, doesn't say that she didn't.
Yes. So I readily accept what Section 3 says of the
Section
Act.
5 tells us when refugee status ceases.
Yes.
And the fact that an earlier application failed is not a circumstance which causes refugee status to cease.
No, yes, no, that's correct, Justice Rogers. Again, the difficulty is all of these provisions, 3, 5, 1, and 2, have to be read together with Section 24.5.
Now let's go to Section 21, which is the right to apply for refugee status. I don't read in that section anything that says that it can be done only once.
Yes.
There's nothing that says it can be done only once.
No.
It doesn't say it can be done twice, and it doesn't say it can only be done once. It's open-ended.
Yes, that's absolutely right. But so on our interpretation of that, that has to be met together with 24.5.
Which is that they must be dealt with in terms of the immigration.
After the process has come to an end, yes.
Now, my notional illegal immigrant in 2020 who had never previously applied for refugee status must also be dealt with in terms of the Immigration Act.
Indeed, yes. Because that's
So the fact that you must be dealt with as an unlawful immigrant and are susceptible to deportation,
yes.
whether you have made a previous application or not, that is the law. So my notional immigrant in 2020, although she must be dealt with in terms of the Immigration Act, we know from the authorities of this court that that doesn't override her right to apply for asylum.
Yes.
So the fact that an unworthy 2014 application is rejected and that that person now falls to be dealt with in terms of the Immigration Act
Yes.
puts them in the same status as any other unlawful immigrant. There is nothing in Section 24 itself which says that that person cannot bring a second application under Section 21. And at least if it is open to what I'm putting to you, you say we must hinge everything on the fact that there's a provision in the Act which says that once an asylum application has been finally rejected, the person must be dealt with in terms of the Immigration Act. So we know that they must be dealt with as any other unlawful immigrant. But we also know that unlawful immigrants are not precluded from seeking asylum.
Yes.
So in attaching the significance that you do to that provision in Section 24, you are asking us to give an interpretation to the Refugees Act which creates the lacuna and the potentially catastrophic results for individuals that were put to you in relation, for example, to the notional Palestinian, and it could be in relation to Ms. Irankuda. I understood the department to say that if she went back, and let us just say the circumstances are dreadful there, and if she is not raped or killed or otherwise dealt with, if she goes back and immediately comes back into South Africa, she can then apply for asylum.
Sorry, Justice Roger, there was quite a few questions there, so if I could...
So I'll remind you of the earlier one. Go back, is it the department's position that if Ms. Irankuda only goes back to Burundi, if she does that little formality and therefore comes in again, she can apply for asylum?
No. I'm trying to get away from the factual disputes, but the position is set out in the answering affidavit. And
we must interpret the Act against a possibility that a change of circumstances may arise which may make it dangerous for the person to return.
yes, no, so what I'm saying is on that particular factual dispute and the email, the department says that that's an incorrect understanding of its position. And I don't want to go there because it has little to do with whether there's a clear right or not.
Yes, so that's why I'm putting it to you as a hypothetical.
Yes.
Suppose those circumstances have arisen and prevail now in Burundi, as they might in Gaza.
Yes.
Do you say that as long as the person goes back to that country and then re-enters South Africa, they can then apply for asylum?
No.
Or is the door forever closed?
No. So I want to be clear on that if there is a right to reapply, non-refoulement would operate. They cannot be returned to their country of origin. They cannot go back. But that is contingent on whether there's a right to reapply or not.
So I'm not sure I'm following. Assuming Ms. Irankuda didn't apply, but went back to Burundi, and managed to survive assuming there were very dreadful circumstances there, and then immediately came back to South Africa, could she then apply for asylum?
No, so the position of the department is, one, if there's a right to reapply, non-refoulement operates. There is no obligation on a person who has an entitlement to reapply to go back to their country of origin.
And that requires us to read Section 21 as containing an implicit prohibition against more than one application. And that, you say, flows from a provision which requires the unsuccessful applicant to be treated as an illegal immigrant.
Yes, and that's not just our position, Justice Rogers. It's the same position adopted by the amicus, that there is a gap.
Well, I'm interested in what position this court should adopt, which is, and we are mandated to adopt an interpretation of the Act,
yes,
if at all possible, that avoids potential constitutional invalidity. Now, if Section 21 doesn't prohibit a second application, and you seek to infer that from a provision in Section 24 that says that they must be dealt with as an illegal immigrant, you have to persuade us that that injunction, that they are now to be treated under the Immigration Act, puts them in a different status from an illegal immigrant who has not yet brought an asylum application even once, and who must also be dealt with in terms of the Immigration Act. Why do you say that your interpretation is so compelling on that point
Yes.
that we should read Section 21 as prohibiting a second application?
So our case is this. The court has to read non-refoulement in Section 2. It has to read the interpretation, the prohibitive provisions of Section 1 about abusive applications. And it has to read Section 24(5) together with the principle regarding finality. So one can't, with respect to Justice Rogers, look at one provision of an act and say, well, it doesn't preclude the application. The court has consistently said you read a statute holistically.
Are you referring to anything other than Section 24(5) as a basis for saying that Section 21 must be read as allowing only one application?
I am also relying on this decision in Ruta, in Abor, and Ashebo that says once the process has come to an end, the shield falls away.
Yes, I don't think either of those cases were directed to circumstances where where by virtue of a change of circumstances, the protection of non-refoulement was needed. Either of them were concerned with the issue we are now concerned with. But as a matter of interpretation, having regard to the text of this statute, its purpose, and constitutional interpretation, is there anything you rely on other than Section 24(5) for the proposition that there cannot be a second application under Section 21?
Well, we also say that it's not there.
Sorry?
So we also say that it's not there. There is no provision of any on any provision of the Refugee Act that entitles a second application.
Silent as to whether there can be more than one.
Absolutely. And on our reading of it, together with Ruta, together with 24(5), together with the question Justice Collopin put to me, which is, what is the framework for a reapplication? When does it end? Who decides it? That one can't simply assume in a mandamus application that particular absence means nothing.
Now, another part of the text, which seems to me to be very important in deciding whether Section 21 prohibits a second application, is the definition of abusive application. Because that definition now makes sense if one accepts that Section 21, albeit read with your Section 24(5), doesn't prohibit a second application, but it does treat it as abusive in the absence of changed circumstances.
Yes, indeed. So our interpretation is that absence, again, I go back to this, which is that the silence actually means something. And in a mandamus application where you have to demonstrate a clear right, it has to be hooked on something. And our interpretation is, I'm sorry to interrupt, that when you consider this court's jurisprudence, the finding of the SCA itself about how non-refoulement operates, which is it comes to an end when a process has finally been determined, and the position adopted by ourselves, adopted by the amicus, and by the respondent that there is a lacuna in a mandamus application that can't be filled in that way. Yes.
There's only a lacuna if Section 21 must be read as permitting only one application, and that's what we've been debating.
Yes.
You say that must be understood in the light of Section 24(5).
Yes.
We've already debated why that may not be a particularly compelling reason, given that all illegal immigrants must be dealt with in terms of the Immigration Act. But what might be, I would have thought, of considerable significance when one comes to text and context is the definition of abusive application, because sub B of that definition refers to after the refusal of one or more applications. Now, it's all very well saying that it's a definition section, it can't confer rights, but on the other hand, we mustn't lightly infer that the lawmaker passed a nugatory or futile provision. So if that is to have any meaning, the meaning must be that under Section 21 you can bring a second application, but that under certain circumstances it may be classed as abusive.
Well, on our reading, that's not the case.
Well, tell me why you say Part B of that definition was included in the Act.
Well, I've given 4 reasons for that. And the thrust of the reasons is that the court must look at what abusive applications means in the context of the entire Act and the process. Now, if the process has come to an end, if we take the notional illegal immigrant that you put to me, Justice Rogers, who goes through a process, who, as a result of changed circumstances in their home country, had been a previous applicant and seeks to apply again, the question becomes whether they have that right to in fact apply again.
So what,
Now,
what
if I may,
application contemplated in paragraph B of the definition?
excuse me,
What is the application which says one or more applications? What
Yes.
are those applications in the definition?
well, one can't rely on this particular provision to say there's an entitlement to bring one or more
Now, I
applications.
just know what applications are contemplated in paragraph B,
No, it could be an application for asylum.
which has
But-
been rejected.
No, Justice Rogers, because one has to ask, again, the case is about a mandamus, with respect. Is there a clear right to the entitlement? And the only place in the entire statute that deals with one or more prior applications is a definition of abusive application.
Are you saying that this, an abusive application is when the refugee has one application pending and brings another?
That could very well be.
It seems to me the lawmaker was then contemplating a very obscure and unlikely scenario.
I don't accept that at all, Justice Rogers. I don't accept it because,
But that is the only... You have to resist the proposition that what the lawmaker is referring there to is a previously rejected application, because then that provision is nugatory.
well, the only way on that is if there's an entitlement to bring one or more previous
That's what
applications.
we're debating. We can't interpret Section 21 and decide whether it confines a person to one application or permit more without reading the whole Act.
Indeed.
And the definition of abusive application is part of the whole Act.
Yes,
So we must, as far as possible, read Section 21 in a way that is consistent with the definition of abusive application.
indeed.
And that appears to envisage that there may be more than one application.
Yes, but the question becomes whether there's an entitlement to bring more than one application. Is there a clear right to do so?
Entitlement to more than one application, it can't be lodged.
No, on our submission, no, Justice Rogers. One can't rely on a prohibitive provision to say it sources a right of an entitlement.
Well, I think we're going round in circles.
Yes.
But I've invited you to the points
Yes.
for me. If I can just say this,
Yes.
if the trend underlying my questions were right, and therefore a second application is permitted, it might be that the Act is not, that one might want provisions in the Act or perhaps in the regulations which ensured that repeat applications were swiftly processed so that they did not become a method of abuse, but that they do not inherently have to be such,
Yes.
shown by other countries which expressly permit a second application.
Yes.
There
Well,
ought to be able to be procedures to accommodate this, and in fact, even within the framework of this Act and the regulations,
Yes.
there is nothing that would prevent the department from expediting a repeat application.
yes, and that seems to be the problem that the SCA says we need to deal with. It says you will come up with a process or procedure to deal with what we say is an entitlement under the Refugee Act. But again, I go back to the debate I had with yourself, Justice Rogers, that the framework doesn't allow that.
I might have given a slightly different answer to the SCA. I would have said, well, Section 21 allows you to do it. But if it's abusive, you're going to be knocked out pretty quickly.
Yeah.
That you and I perhaps differ on that. In fact,
Yes, but that can be legislated for. But yes, Justice Rogers, indeed.
Thank you.
Thank you, Mr. Rampal.
Thank you very much, Deputy Chief Justice. Those are our submissions.
The court will adjourn for 20 minutes.